Once again on the record, and this would be in the matter of the State of Ohio versus Michael Dixon, 20 CR 0201, and we're back from a short break. The jury's present. Mr. Dixon is present, as is his defense team, and then the prosecution team is also here. And I believe at this point we'll have the rebuttal argument from the prosecution. Thank you.
Thank you, Your Honor. Good afternoon. If Joel or myself said something or say something in closing arguments that is not how you remember it, please use your collective memory about how things happened or what the testimony was. We're not trying to trick you or confuse you or anything like that, but you can imagine over the days of testimony, sometimes what we heard or saw may be different than what you did. Look, the defense counsel asked you, he wants you to be confined to these 60 seconds, right? These 60 seconds. Well, this thing didn't happen in a vacuum, ladies and gentlemen. The defendant didn't kill James Whitaker in a vacuum. He decided to kill him over the course of a period of time. This wasn't just a moment of 60 seconds. He went and got the gun from his brother. Couldn't he have used one of Whitaker's guns to go hunting or something like that? But no, he had to get a gun from his brother and take it and use it to kill James Whitaker. His story doesn't add up. The state isn't just picking and choosing what parts of the defendant's story to believe. The state and the law enforcement officers are believing the parts that are supported by evidence. Not just by this man's word, because he has lied on top of lies on top of lies, multiple times through multiple days, through multiple weeks. He came in here today and admitted different changes in his stories. This wasn't just, he lied, and then ultimately when the police caught him, he came clean. That is not what happened. Although defense counsel would like for you to believe that, that is not what happened. He did a walkthrough, and he lied about things there, changes his stories there. He went and took law enforcement officers on a wild goose chase, according to him, looking for this jawbone that now he says didn't really exist. He really didn't take it. And when I asked him, well, why did you have law enforcement go through this? Like they didn't have anything better to do than be with this defendant looking for something that didn't exist. Why did you do that? He says, I don't know. Ladies and gentlemen, this is a man who will do anything to get out of trouble. He will do and say anything to get out of trouble. And he admitted that. I asked him that question. You will lie to get out of trouble, won't you? Yes, I will. He lied to keep himself out of trouble. He attempted to lie to keep Melody out of trouble. He lied to attempt to keep Mr. Strickland out of trouble. And not only did he lie, he did things. It wasn't just him saying things. He actually did things. To prevent himself from getting into trouble. Please, ladies and gentlemen, do not check your common sense at the door. People are judged by a jury of their peers so that their peers can bring common sense, not by the elite in society who may not have common sense. The people, you all, bring your common sense when you judge his conduct. And when you apply common sense to his conduct, it won't survive. It won't last, because you know it is a lie. You know it is a lie. My son the other day asked me if the milk was good at our house. Dad, is the milk good? I said, smell it. He's like, the date on it's kind of fuzzy. I can't really, it's kind of rubbed off a bit. I said, well, smell it. And he smelled it. He said, it doesn't smell good. Well, son, it's not good. His story, the defendant's story, doesn't smell good. That's because it's not good. It's filled with lies on top of lies on top of lies. The defense counsel would have you believe that a man who had been up for 2 or 3 days, had multiple bouts of snorting meth, killed a man, burned his body in a burn pit, lied to the police multiple times over multiple days and weeks, lived in his house, ate his food, sold his things, rearranged the crime scene, had a friend help him rearrange the crime scene, produced a fraudulent suicide note, and then claimed self-defense. And then he's going to say, oh, this was self-defense. And then when he gets to court, he continues to lie and to change his story. The defendant has changed his story so many times, even he doesn't even know what the truth is anymore, ladies and gentlemen. He is willing to do anything to get out of trouble, and his story is preposterous. He wants you to believe that James Whitaker, a guy who's been hunting for multiple years, all right? Let's take his story and break down the one story that he wants you to believe. Disregard all his other stories that are lies. Let's talk about the one story that he wants you to believe, right? Let's break this down a bit. James Whitaker is at his house. It's 4 o'clock in the morning. James Whitaker is at his own home, his own residence. He hears the defendant and Melody come in, and he comes out with a gun. And he's yelling, "Get out of my house," cussing at them and whatnot. And Melody's just going to go and use the bathroom. She's just going to, I guess she's got to go. She's got to go, right? There's a man there threatening her with her gun, but yet she's going to go to the bathroom. So the defendant decides, oh, well, he's got a gun. I got to go get my gun too. And he runs downstairs, gets his gun, and comes back upstairs. And James Whitaker does nothing. He does nothing. He's just standing there. The defendant, if you believe his lying story, pulls up his gun, shoots double out buck through a hole this big in between 2 bookshelves, and shoots the victim in the face. Shoots James Whitaker in the face. A man who's been trained with guns for a long time. All the witnesses said that. He was an avid hunter, and he didn't get a single shot off. He didn't get a single shot off. And the defendant threads his shot through a couple of inch bookshelves without any of the buckshots scraping the bookshelves. That does not pass the smell test, ladies and gentlemen. It does not. The defendant admitted, when I confronted him, the defendant admitted that he changed his story only because law enforcement caught him in lies. If the police would have went with his first story, that would have been it. The defendant wouldn't have reapproached them and said, hey, it's not really how it happened. He admitted he only changed his story because he was confronted with the truth. Things didn't add up. Law enforcement does an investigation. Law enforcement looks at evidence. Law enforcement looks at facts. They gather evidence. He didn't lead them to the truth. He may have helped. But there was an investigation that was going on. He did not go to law enforcement. He didn't tell anyone that he killed James Whitaker. He didn't tell family. He didn't tell friends. He didn't say, Julie, your dad pulled a gun on me. You know how he is. Your dad pulled a gun on me. It got out of hand. I had to shoot him to save my life. He didn't say that. What did he do? He took James Whitaker's body to a burn pit, took a nap, and helped fix Keith Strickland's car? Is that the behavior of someone who was in fear of their life and justifiably killed somebody? No. That is the behavior of someone who purposefully took another man's life and was attempting to take his things and sell them. Didn't tell anyone about James trying to kill him, about James being a threat to him or his daughter. He didn't tell anybody that. Fact of the matter is that self-defense doesn't apply because there was no defense of himself. The defendant wasn't afraid for his life or for his safety. He was hopped up on meth that night and for whatever reason decided to kill James Whitaker. Now the defense counsel says, motive's important. Don't you really want to know what happened? Don't you really want to know why the defendant killed James Whitaker? Yeah, I would like to know that, but we don't. You know why? Because of this man, because of the defendant. He attempted to erase all existence of James Whitaker. He had 20 plus days to clean that crime scene, 20 plus days to rake over that burn pit, 20 plus days to go through that burn pit and take out teeth and other things that may be retrieved of James Whitaker. And defense counsel says, why would he do that? Why would he kill his meal ticket? Well, as the law does not require the state to look into the mind of the defendant, because we can't. We can't, ladies and gentlemen. Only this man knows why he killed James Whitaker. I can't look inside the mind of the defendant and see what is in his mind. I can't see what is in his mind when he uses meth with his daughter, that he goes down into the basement with his daughter with one bed and one bedroom and makes sex noises. I can't look inside the mind of that. And that's why the state's not required to. We're only required to prove that it happened. The state believes the defendant when it is supported by the evidence. And the evidence supports that he murdered James Whitaker with purpose. He did it knowingly. And he's willing to do anything to stay out of trouble, including coming into court and lying to you all, including cutting up the body of James Whitaker and burning it in a burn pit. Can you imagine the smell of a burning body as the defendant is raking over it? That is what the defendant is willing to go through to not get in trouble for his own actions. And then he says, well, I didn't cut up the bones. I didn't cut them up. Well, then how did they get cut? You heard the anthropologist say that they were cut with instruments. And also, one other key item, why wasn't the rest of the skeleton found? If they weren't cut up, you would have a large pile of essentially a full skeleton. There's only partial remains left after law enforcement officers went back to that burn pit multiple times to try and find the remains. Additionally, the anthropologist said that those cuts were pre-burned, which is very important. They were cut before they were burned. They were cut before they were burned. Meaning that the defendant dismembered the victim's body before he put him in the burn pit. That's consistent with the evidence, ladies and gentlemen. That is consistent with the evidence. If he didn't cut up the victim, dismember his body, crush his skull and bones, and remove his teeth and crushed his teeth, we would have a full cranium. We would have teeth, pieces of teeth in the burn pit. You heard the detectives, I believe it was Detective Robinson, I know it was one of them, said they used a shifter to shift through the ashes to make sure they found the little pieces of bone. There were no teeth in there. That's consistent with the defendant smashing them. Defendant says that he didn't produce the note. He doesn't know who did it, but he didn't write it. That fake suicide note. It was part of the enterprise, ladies and gentlemen. That's another piece of evidence to show that the defendant did not act alone in covering up the death of James Whitaker. He wants you to just believe that he was looking out for his daughter. That he was looking out for his daughter. The same daughter that he does meth with. Those aren't the actions of a concerned parent. Bringing her into a house and having her walk up the stairs and go to the bathroom when there's a guy there brandishing a gun saying, "Get out of my house." "Oh, I got to use the bathroom first. 1 second. It's been holding it for a long time." That's not reality, folks. That doesn't survive common sense. Those are lies on top of lies on top of lies. And I'd submit to you, if the police were here and we weren't at trial, if the police were here confronting him with this evidence, you know what he'd do. You know exactly what he would do. He would come up with another story. We would have yet another story to be talking about here. Ladies and gentlemen, the state doesn't want you to believe the defendant, Michael Dixon, because he said it. Believe him because it's supported by the evidence. And the evidence supports that he purposefully killed James Whitaker. He attempted to do everything he could to cover it up. He had help in attempting to cover it up. Look at the evidence. Use your common sense. And when you do, you'll find him guilty of all of the charges. Thank you.
Thank you.